Well, thanks. In this concluding session on trying to focus on the future of the International Criminal Court, of the Rome Statute, and the international justice writ large, I think this has been really a terrific 2 days of discussions, and look very much forward to this last one. I believe this will be a session, if perhaps, where we'll have a number of people who would like to intervene, and so we're going to try and have everyone respect on the platform the limitation, and on the intervening side the request to try and keep your comment or observation or question to the 1 to 3 minute range. We will be doing and I hope people will remind me if my brain is gone again at the end of the session, but we're going to do a moment of silence as was requested for the victims that have lost their lives in these last 20 years. And I thought, as we said, we've had a number of people mention those wonderful souls who were so fundamental to the Rome Statute and the ICC that have passed. And I did not want to forget one that was, I think, another, if there are singular individuals without whose support this would never have happened, and that was the Prime Minister A.N.R. Robinson of Trinidad and Tobago, who very, very strategically called for the General Assembly to take this issue of creating an international criminal court up in 1989, and I am fairly certain that had he not started that process with the Law Commission then presenting a draft statute in 1994, that we may very well not be here today. So I hope we'll include A.N.R. Robinson when we have our moment of silence at the end here. So we're looking forward to some excellent additional statements from, again, some diverse but also wonderful experts on the Rome Statute and the ICC. And our very first intervention in this session is Richard Dicker, the Director of International Justice Program of Human Rights Watch, and of course was at our very first meeting of the coalition at the Church Center in New York in 1995, and I think is one of the pillars of international justice globally. Richard.
Well, the conversation that we had yesterday and are continuing to have today is very exciting. And I am going to frame my remarks this afternoon in the context of two questions that were posed in the program for this panel. First, opportunities to position the court in a more positive light, and then second, the role of the Rome Statute System in a world where multilateralism is on the defensive. As to the first question, situating the court in a more positive way, I don't think it's helpful to proceed with a one-sided view. I believe as important as anything else, over its 15 or so years of operations, the ICC has indeed become the permanent address for accountability. But what that means is that people all around the world, regardless of the legal relationship between their country and the court, whether that country is a state party or a non-state party, look to, as it's often called, the Hague, when serious crimes are committed. And that looking to the Hague fuels and sustains an expectation for justice that is so crucial. At the same time, I think it's fair to say, and Darrell Robinson spoke to it earlier, the court has taken a beating in the realm of public opinion, sometimes state-driven, most times state-driven, as we've seen the work and efforts of Omar al-Bashir, of Uhuru Kenyatta, and others, with or without their publicity firms, casting the court in a negative way. I believe, and I said this yesterday, I think we have to be prepared for the reality that as long as this court pursues its mandate, it will continue to take a beating from those who fear accountability and what the institution represents. I can tell you from my perch in New York, the attitude of the Russian Federation towards the ICC has changed considerably since the prosecutor announced that she was opening an investigation in Georgia. And I cannot foretell or even imagine what might be the reaction from Washington, D.C. and the current administration if this court goes forward with an investigation in Afghanistan that includes U.S. nationals. So this is always going to be part of the picture, being slapped by powerful states who fear the court's reach. Now, how to change that? I want to emphasize change, not end that, because it will be with the court for a long, long time to come. I think first and foremost, the way to limit that is for the institution to demonstrate excellence in all of its work and its proceedings, to demonstrate its independence, its impartiality every step of the way. And the means for that to happen, I think the dedicated staff of the court need to strive at every turn to put the interests of the institution, the interests of victims, the interests of justice first and foremost. I think the Office of the Prosecutor needs to select with care the situations in which to investigate. I think the cases need to be selected that have crimes that are most representative of the serious, most grave crimes committed, and those responsible need to be charged without fear or favor. I believe it's essential that the proceedings are expedited, consistent with fair trial guarantees, and all this needs to be done with an eye to maximizing the impact and meaning of the court's work in the communities most affected by the crimes. That is not an easy to-do list by any means. I think that states parties, and this is where we have a role, need to be pushed away from the view that the relatively small amounts of money this court receives is somehow excessive, and that states parties need to be pressed not to use the budget as a cudgel against the court in any way to interfere with the exercise of its independence. That's on the ICC side, but I believe that the court in a world, or the Rome Statute System, in a world of shrinking multilateralism, has a crucial role to play. The commitment to accountability represented by the Rome Statute and its system of complementarity stands side by side with those country situations where the court has no jurisdiction, be that Syria, be that Yemen, be that Myanmar, be that South Sudan. I think even in those situations, the ICC has an important role to play and is relevant in significant ways. Certainly, the stronger the ICC is, the stronger the values and commitment to accountability and justice as a counterweight to impunity, to what we see evolving in many non-states parties' territories. I think that's a crucial role for this court to play, even where it does not have jurisdiction today. We can't wait, however, for that role to be played, because victims in these non-states parties, as victims in states parties, need and demand justice, and evidence needs to be collected and preserved for use in future trials. There are small steps that need to be taken, and without putting too much burden on it, I think we see in the launching of the independent, impartial, investigative mechanism for Syria, an important, though small, step in gathering up fact-finding collected over 7 years' time for organization in criminal dossiers that could be used in trials against future accused. At the same time, and I'm not sure he's still here with us, but I saw the director of the European Union Genocide Network here, and I flagged that because universal jurisdiction in these countries that are not state parties to the Rome Statute has an even more vital role to play than it did in 1998 when Augusto Pinochet was apprehended in London. So the work of gathering evidence, putting it into criminal dossiers, and those dossiers being utilized by states with organized, dedicated war crimes units that have been created by their governments is absolutely essential in limiting the impunity for crimes ravaging civilian populations where the ICC does not have jurisdiction. And I would say, and we'll end on this note, going back to states, and again bringing in our role as civil society, that this will require more resources. I reject the argument that it's either the ICC that gets funding or domestic war crimes units that get funded. In fact, I think our message to states needs to be essentially wake up and smell the coffee, because if you are standing against impunity, you need to fund not only the court, but alternative means to bring about accountability, and it's not pick one or the other. And I think that has got to be the message that we as civil society bring out in this anniversary year of the ICC to states parties worldwide. Thank you.
Thank you. Next, we have Jennifer Trahan, the Associate Clinical Professor, Center for Global Affairs, New York University. And one of the reasons we asked Jennifer the last couple of weeks to join us was she organized a conference on the future of international justice. And the papers may be gone. They're on the back of the table there if there's any left. And she will explain how if you didn't get one, you will be able to get one from her. So Jennifer.
Thank you for inviting me. It's a great honor to be here. I'm delighted to see the future of international justice on the program. I have a few of my own personal thoughts, and then I did kind of two facets of a study. So I interviewed 20 of the top tribunal prosecutors, current and chief prosecutors, and past of Sierra Leone Special Court, ECCC, ICDY, ICDR, ICC, and various others. I think a couple in the room were also in this study. And then I conducted a New York symposium with legal advisors, NGO representatives, and academics to talk about the future. And copies are in the back table if we run out. That's Heather Craig, and you can give her a business card, and we'll send it to you electronically. First, I just want to say to any students or young practitioners in the audience, welcome. It is wonderful that you are engaging. We need your enthusiasm and novel ideas in this field. To the academics, I somewhat echo Daryl. I would urge temperance of armchair criticism. We love to hear ourselves talk. Let's make it constructive. And then always to remember that our job is also to inspire the next generations. And I urge academics to also take your students into the field. Take them to Srebrenica, have them talk to survivors, take them to Murambi. These are places they will never forget, and you won't forget them either. To some of the largest human rights organizations here today, despite being an enthusiastic supporter of so much of your work, I say that the ICC now has a fourth crime, the crime of aggression, and you need to embrace this development and realize that working towards deterring aggressive use of force is a human rights violation, because human rights are massively violated in times of war. To states parties who maybe were somewhat disappointed by the precise language in some of the activating resolution, the language that appears to have been adopted. Yet I say you have achieved something significant. This is very historic, and we all know there will be limitations to the potential of Security Council referrals. Yet even that start is potentially very significant in terms of potentially deterring aggressive use of force on the global stage. But because of these limitations, another way for cases to get to the ICC is critical, and therefore there must be further ratifications and/or other ways to broaden the court's jurisdiction on crime of aggression. To representatives from states and NGOs and academics, I will give one of the takeaways from our New York workshop is that they reflected maybe they don't do a very good job when seeking funding for the tribunals of explaining all the indirect benefits of tribunals. So we all know that if you do numbers prosecuted over total cost of a tribunal, I think for none of our tribunals will that number come out very well. But that's way too simplistic an analysis. There are so many external benefits, and I'm afraid we don't capture these all very well. And there's a somewhat alarming trend in political science circles. If they can't quantify it, it must not exist. And as I was at the ICDY Legacy Conference and we're all assessing legacy, they're trying to quantify everything. And I think there's some things that are going to escape quantification. So what is the value of rule of law being done in a country that has not had it? What is the value of adding crimes to the judicial code? We don't know. These are benefits, but they escape it. And I think it's hard, and it's maybe messaging that needs to be told to the funders. And I think maybe many of us can work on this. Another takeaway from the New York workshop, some of those who work only on ICC said it was refreshing to work on the system of international justice because they're siloed only into ICC work. And I think it is important that if you support the ICC, as Richard alluded, it can't do everything. You should also support domestic capacity building. And I know there are people here who are working on domestic capacity building. That's fantastic. But those I surveyed and those I met with said it's still not being done in a coordinated and systematic way. And if we're thinking of the future of the field, maybe 20 years in the future, I think this still needs to be done. Another takeaway in terms of complementarity, where I think we've seen evolution, and this was reflected in the workshops, was that when we used the word complementarity a couple years ago, we probably thought, oh, this means domestic prosecutions. But when I was talking with individuals, they said, no, regional could complement. A hybrid could be complementarity. And this brings us to the notion, also Richard alluded to, there needs to be tiers of international justice. We've seen this for the former Yugoslavia, we've seen this in Rwanda. No tribunal can do it all. The CAR hybrid, the Kosovo hybrid, these are not competitors to the ICC. So I'm not saying there could not be times that another tribunal is introduced in a way that with nefarious purposes, but I'm saying there are times that we should consider alternatives. And in addition, I don't mean, we actually need multiple tiers of justice. There are just too many crimes out there. Our biggest challenge, and this is my final substantive point, is on complementarity. We have tremendous problems on the due process issues. I think if a deeply flawed group trial in Libya of Sanusi and Gaddafi, that's complementarity, then I think we have problems with complementarity. Having also, and I've studied the Libya trial, and I can give you a lengthy law review analyzing the flaws, but I've also analyzed the flaws of the Iraqi High Tribunal, what went wrong with Dujil and Anfal, and I think we also should be concerned about trials in the region. So to conclude, we must work with determination. We should not give up even on the seemingly impossible. I would put that there, a tribunal for Syria, a hybrid regional criminal tribunal. And then I want to announce I'm starting work on a new initiative on the illegal use of the veto. So it's come up a fair amount in our dialogue. And the concept and I'm looking for NGO supporters, so many of you in the room. The idea is the veto seems to be treated as if it's above all sources of law. Well, actually, there's this thing called jus cogens that's on top. And then there's the purposes and principles of the UN Charter, and that's on par with the veto. And then individual member countries also have obligations, such as under the Genocide Convention, to prevent genocide. So when P5 or any security, P5 would veto in the face of, for instance, genocide, how are they fulfilling their obligation? So this is a new initiative. I'm looking for NGOs who want to work with me on this. And the idea is to ultimately go to the GA and ask them to ask the ICJ for an advisory opinion. Are all vetoes legal? Or are there other relevant bodies of law? And I mean vetoes in the face of atrocity crimes. So please come talk to me if this interests you. Thank you.
Put this down. Thank you. Our next presenter is Mr. Andres Vam-Goldman, the Executive Director of Justice Rapid Response. And Andres also is someone who's been in the trenches on this since, I think, before Rome, and we look forward to hearing from you.
Thanks, Bill. Thank you, everyone, for coming. It's very good to see so many people still here at the last session of the afternoon. I'm going to speak about overcoming the challenges to the Rome Statute System, which in my view includes the International Criminal Court, although I will have something specific on the court itself. And I'd like to start by seeing if we can go back and agree on a premise that the role of the Rome Statute System, with the ICC as its pivotal central element, is to sustainably establish the rule of international criminal law in the world. I think, unless somebody wants to disagree, I think that's basically the reason why we've created the Rome Statute System. And to make it, the Rome Statute System, the international criminal law, a viable alternative to the rule of violence in correcting past injustices, and thus to help the many recurring cycles of violence around the world to come to an end. I mean, we're not doing this in isolation. We're doing this for a particular reason, and that has to be the reason why we've created and we're maintaining the Rome Statute System. This has to be the backdrop in looking into the challenges and the solutions to the challenges that we're facing today. We've heard a number of speakers discuss that it is a more difficult time that the court and the Rome Statute System is facing. Some have alluded to some of the difficulties. I would say that of those, I would pick a particular one that I would like to highlight. And that is the biggest difference of today and maybe 20 years ago, is that many of our leaders have lost sight of the goal. Why have we created the Rome Statute System? Why is it necessary for peace and security around the world? And I think more than any other reason, a direct result of today, this is a direct result of today's political timeframes, which seem to seldom stretch beyond the next election. And the direct effect of this on the Rome Statute System has been fewer international accountability opportunities. And if there is one thing that is creating the difficulty for the success of the Rome Statute System, is the shrinking accountability opportunities in today's world. Of course, one reason is the expectation that somehow the International Criminal Court would occupy this space. And we know, and many of us have discussed this over years, and a number of speakers have mentioned this today, it's an elusive goal, not just because of the court's lack of global reach, which we are all trying to fix, or the understandable prosecutorial policy of focusing only on those bearing the greatest responsibility. I think there's another reason, and it's because we have not been sufficiently clear and unequivocal in that the International Criminal Court is a court. We have, and in some ways we are treating it, and we are expecting it to function as an international institution. And what I mean by this is that the ICC has not had anyone but itself to watch its political back. Now, of course, the entity that is able to and that should be doing this is the Assembly of States Parties, and it's that body that can pick up this role. And by this, I do not mean that it should encroach on the court's independence. But I do believe that there's a way for it to pick up its role as to watching the court's back. And I do believe that it's possible if we have strong and focused leadership in the Assembly of States Parties. But I think there is another and even more concerning challenge to the success of the Rome Statute system. Today's short political horizons often seem to be satisfied with, let's say, a less rigorous solution to activities that would fall under Article 5 crimes. Let me say, for example, that dealing with activities that may fit under Article 5 crimes are often referred to and dealt with as terrorism. Because, for example, in some countries, some post-conflict countries, this is a very useful way for those countries to ensure continued funding from a number of donors who are interested in fighting terrorism. More recently, however, some countries whose motivations are not related to funding have, in certain situations, begun to follow suit. And the dangerous challenge that this situation creates is that if perpetrators of these crimes, activities that could be Article 5 crimes, are not brought to justice under the system that exists to establish the rule of international criminal law, then we will never be able to convince affected populations of the effectiveness of the Rome Statute system as an alternative to the use of violence in righting past wrongs. And the stakes for this are very high. We stand to lose the significant opportunity that the creation of the Rome Statute system has provided to help break recurring cycles of violence by convincing populations that the rule of law is an alternative to that violence. Yet overcoming this scenario is really not rocket science. Here are some ways that we can deal with this, and we are doing some of it, and we should be doing it some more. States that are able must exercise their jurisdiction to investigate and prosecute alleged perpetrators of Article 5 crimes under national jurisdiction. In cases where states are willing but unable to investigate and prosecute, mechanisms like the one that I lead, Justice Rapid Response, but there are others, should be supported to help them provide expert, professional, peer-to-peer mentoring that enable such states to maintain national ownership and responsibility to investigate and prosecute those crimes. Professionalizing international criminal justice at both the international and national levels is the most effective way of ensuring that the laws are followed, making sure that accountability will be credible, again, which is the best way to instill a sense of confidence in the Rome Statute system among affected populations. We need to continue to work together for the universality of the International Criminal Court. But we don't have to put all of our eggs into that basket. Where national prosecutions are unlikely, and the ICC does not yet have jurisdiction, ad hoc or hybrid tribunals still have a very useful role to play. And for those states worried about the cost of these other accountability mechanisms, I have 3 words. It's management committee system, first developed for the Sierra Leone Special Court. To sum up, We must keep in mind that the idea of the Rome Statute System and international justice is to provide an alternative to conflict and violence as a way to solve issues and right past wrongs. We can only achieve this goal if we adhere to the system that we've created. We need to keep supporting it. Thank you.
Thank you. I'll introduce the last presenter before we go to participant participation. And I know it's been somewhat controversial over the last few weeks in putting this together, that we gave a special focus to highlight experts who had either been part of the Rome negotiations, no matter whether they were international organization representatives or government representatives or NGO representatives or journalists, etc. And but I think it has been a very valuable to bring this group together as much as possible in launching, which I says we hope will be one of many, many events around the world this year on the Rome Statute's 20th anniversary. Our last speaker is Klaus Rackwitz, who's the director now of the International Nuremberg Principles Academy. Klaus was a member of the International Criminal Court Advance Team. He was the second staff member of the Office of the Prosecutor, and he served 8+ years as the OTP's senior manager. Klaus.
Thank you very much, Bill. I will be brief because time has run out almost. Yes, as a practitioner that I am, I started my legal career as a judge in Germany. I will focus on the practical aspects of the Rome Statute and the way we hold trials these days. In Nuremberg in 1945, the IMT had it off in the city completely destroyed. 24 accused persons, no technology almost. IBM for the first time introduced simultaneous interpretation, 4 languages, and the whole trial took less than 11 months. Now the Cecily trial took more than 11 years. What are we doing wrong today in order to have the trials going that long? And for me, this is one of the most challenging aspects and one of the most challenging concerns that we had in the seminar that Fabrizio mentioned at the swearing in of the first prosecutor of the ICC. How can we make sure that the proceedings take place in a reasonable amount of time? And why is that so important? And I'll give you an example for that. In Germany, we had a trial against FDLR representatives that took place in Stuttgart. And the presiding judge, after 2.5 years of trial, opened his delivery of the judgment with the word, "This trial is impossible to hold." Now, if the richest, or one of the richest countries in the world with a perfect infrastructure is not able or feels not able to hold a trial under the international criminal law, how can we expect a lesser resourced country? How can we expect a destroyed country to exercise its duties under the complementarity regime? And that could lead to the fact that complementarity remains a good idea, but is not implementable in practice. And I think that the length of the complexity of the proceedings is a very, very important element here. Just the other day, I read a decision from the ICC. It was about a defense request to the prosecution to sum up the facts of a case, and the judge rightly said, well, actually, you had enough time, but on the other hand, in the spirit of a fair trial, the OTP was ordered to bring a case summary, a trial brief, not more than 300 pages. Well, sorry, the case is not that complicated. I know about it. But why does it need 300 pages? And what signal do we give if a single document in a trial that's going on for years is allowed to have 300 pages? That is difficult to explain to victims. That's difficult to explain to other participants. That's difficult to explain to our donors. But it's apparently, to some degree, the reality of courts. I can only commend President Fernandez for starting to seriously work on that with the Chamber's practice manual. And I think this is a very, very important step into the right direction, And I can only invite and encourage all other ad hoc courts, tribunals, and whatever to go along that route. Because if we do not make these trials digestible in a way that lesser resourced countries can apply the law, regional courts can apply the law, we will always have the situation that a few flagship cases take place per situation, and the vast majority of low and mid-level perpetrators have a good chance to remain unpunished for their and that is actually destroying the idea of the deterrent effect. Those who are in the top positions, they might even flee around. And those at the middle and low level, there's nobody going after them. That would create an impunity gap, which nobody of us wants. So my plea is, if we talk about development of the Rome Statute in the next 20 years, let's try to make the trials more digestible so that we can have many, many more. Thank you.
That was without notes. So it came from the heart and the mind, that's for sure. Okay. I have a list of those who've asked to intervene, and we'll now, and if we get through this, then we'll go to some additional ones. The first will be Judge Politi. And Judge, we do need to try and keep these as succinct as possible, please. Okay.
Yeah, very, very succinct. I just want to thank the panelists, the present panelists, and the former panelists, because I belong to the former to the former panel. And I would like to join David Donat-Cattin. He said he was the only panelist who was born in Rome. I'm the only discussant probably who was born in Rome or around Rome. So Rome is well representative, not only in the name of the statute, but also in physical presence here. A couple of words about aggression and the achievement consisting in the jurisdiction of the court of the crime of aggression. The process of getting to aggression being within the jurisdiction of the court was quite peculiar, I would say, because nobody was interested in aggression for a long time. I remember in 1997, there is the first proposal by Italy and Egypt, which means Sherif Bassiouni and myself, who decided to move the waters and present a proposal for the definition of the crime of aggression. There was no comment, no reply. There were no movement in the negotiation. Nobody really was very interested, or if they were interested, they were afraid of sabotaging the court, or maybe it was the bad quality of the legal writing that did not inspire people at that time. But the interest increased at the Rome conference. We finally got there. I tried to be as short as possible. And this is an achievement. It's also a big challenge for the court, because the court will be facing a number of problems of internal organizations. For instance, the pretrial division needs to be reorganized and reassessed in light of the amendments. And then there will be probably issues of complementarity that are unknown so far. And we don't have to forget also that there are limits in the compromise reached on the crime of aggression. So the risk not only of high political stakes, but also the high risk of selectivity will be there. So it's a big challenge. It's an achievement and a challenge for the court. I want to call the attention to this point. And then two more considerations. One relating to the tremendous impact that the creation of the court and the work of the court has had on various generations of students, young researchers and lawyers. In other words, on young people that when they're facing crucial decisions about what to do with their life, they turn to international criminal justice, to human rights, to humanitarian law. at various levels. I mean, I'm a law professor, and I see these people coming to me day by day, asking to work on writing a dissertation, following special courses and programs, joining groups of civil society with very defined objectives: individual accountability, protecting the rights of victims, respect of the rule of law, and the prevention of future atrocity. This is an impressive development from a generation of very few people who had in mind just the utopia of international criminal justice after Nuremberg, to a growing multitude of youngsters who see the fight against impunity in action and want to contribute to its success. And then a challenge that I see that probably has not been too often or too strongly underlined so far: how to enforce human rights norms through the ICC and punish those responsible for atrocities committed in times of peace. I think this is an important aspect. At present, situations being investigated and cases before the court are basically those concerning conducts carried out during ongoing or past conflicts. Criminal conducts that are carried out exclusively during peacetime and not yet been the object of adequate attention by the court. For example, and there were some hints during the discussion today, cases of police brutality amounting to widespread acts of torture or ill treatment, human trafficking within migrations, massive deportations, cases of systematic enforced disappearances. There are instances in which there are clearly some jurisdictional obstacles, and we're now going into the discussion of what the Security Council could do with that. But others in which this is not the case. And it's probably a matter of culture and adjustment of international criminal justice to the idea that the fight against impunity needs to be carried out with the same determination in case of grave violations of human rights committed in times of peace. We don't have to forget that when we are drafting the article on crimes against humanity, this was strongly underlined in Rome, and we say and continue to say that the relations between crimes against humanity and the presence of a conflict has been completely severed, this link. So we have to be consistent with that. There are some initiatives by the prosecutor now. I don't name states, but there are at least at the stage of preliminary examination, and I think this progress and this tendency goes in the right direction, and I think it's a welcome trend that needs to be encouraged. One really final, the point of complementarity and due process. I'm very grateful to Jennifer Trahan for having raised this, and then remind me of the effort that I made at the time of the discussion in the negotiations before Rome with John Holmes, with Derek Robbins, to try to put as much as I could of due process into Article 17. Probably was not enough, but maybe there could be a development in the case law of the court that would give the real importance of this aspect in assessing admissibility. Thank you.
Delia Sator? Yes.
Thank you. Some 29 years ago, a very young, vulnerable public service officer entered the great halls of the United Nations, and my first assignment was to deal with the establishment of the International Criminal Court. I had black hair, sort of with brown in it. You can see the color of the hair now. But that was just part of the beginning of great history for me and for my small country, as well as for the Caribbean countries. For the past day and a half, we have heard observations, comments, recommendations to take us forward. I believe in being very positive on the future of the International Criminal Court and the way forward for international criminal justice. There are challenges. With everything in life, you face a challenge. It's your approach to how you deal with the challenge and the support mechanisms you have around you that will be critical. And in this regard, the role of the coalition, as well as the like-minded group of states, have led us to where we are today. And one can only say a good big up, as young people in the audience would say. Every generation has had its disruptions, but have been managed somehow or the other to get over them. The ICC was not created to create solutions to the geopolitical threats. That is not its aim. It's to deal with something more on accountability, dealing with victims, dealing with the abuses, and seeing that international criminal justice gets its fair share of light in the sunshine. More, however, needs to be done, as we are all aware. But for a small country that believes in peaceful settlement of disputes, the rule of law, sovereign equality of states, this court is a great step forward for us when we are unable to deal with situations. Let us therefore help the court to achieve what it was created to do. At one time or another, there must be a piped dream. But with those who have no dreams, nothing can happen. If those who did not dream about the discovery of the light bulb, the telephone, etc., where will we be without social media today? We would be living in the dark. This is the time for us to live in the light. And this is where I would like to pass the baton to the next generation, because I have done my bit for mankind. It is now left to the others. What we have to leave behind is a court that will have adequate resources, that will recruit and appoint the best personnel possible, the understanding that justice delayed is justice denied, and he who does no wrong has nothing to fear from this court. Finally, we can assess the court on its work over the past 20 years. The court itself has a responsibility of looking at itself and coming to us, well, those who are states parties and NGOs, the civil society, to see how we can help. The support of all of us must be pivotal in planning for the next 20 years. I will not be here in the next 20 years, so I pass the baton on to the younger generation. Thank you.
Daniel Adiria from AFLA. Where are you, Daniel?
20 years ago, 1998, I could barely write my name on a piece of paper. But now, here I am, again, 20 years later, in this forum, celebrating 20 years of the existence of the Rome Statute and the ICC. Coming from a country that has seen human rights abuses in all spheres of life, that is Uganda, and being cognizant of the Rome Statute establishing the ICC, that it does not prosecute crimes that were committed prior to the entering in force of the Rome Statute. My question is, how do we address the issue of accountability with the history of unpunished violence? Does accountability fly in different colors? Because we have victims across the bridge those that crossed with the Rome Statute and those that were locked out. How does the international criminal justice address this issue? Thank you.
Ahmed Mohammedin of the Darfur Union. Mohammed.
Ahmed Mohammedan. Indeed, victims need and demand justice. Need, so far it is contextualized. Demand, I have not seen it. And I can go back to this afternoon's panelist, and that was Lorraine said that victims are crucial, not only theoretical, but so far, 20 years now, are still theoretical if I put myself in the shoes of the victims, particularly victims of Darfur. And in the morning, the concept of complementarity and cooperation have been clearly explained. But in the context in which one of the panelists said that ICC has to function in an environment where everything is politicized, and Professor Robinson also said that, okay, everything is politicized. In such a case, and particularly if I say that I am ICC, and I was created in order to combat impunity for the heinous crimes of genocide, war crimes, and crimes against humanity, what can I say to the victims? Can I just go and say that, okay, there is no complementarity, or at least it has not been materialized. We do not have any cooperation from your government. We're not going to do anything for you. Isn't it the high time that International Criminal Court, and perhaps with the help of CICC, to push forward for the state governments, ASP members, in order to themselves push forward this idea of that Richard puts clearly this morning, and let me quote, if I can clearly quote it. Use of conditionality as an accepted tool in pursuit of apprehension. And as a victim, I think that if we take that route, that could be a quantum leap after 20 years. If not, what should we do? Another thing, trust fund. As a person, I have heard long time ago, but as a victim, I don't know what trust fund is. Perhaps trust fund needs to explain more itself to the victims. And isn't also high time that trust fund, one of them said that they do not have funding, isn't it that it has to push, or at least ICC has to push ASP members, particularly those members who are in the EU countries, who are now funding in the pretext of stopping the immigrants from Africa coming into Europe, paying, if not billions, millions of dollars to the perpetrators, and particularly al-Bashir and other two people, now three, and now al-Bashir actually is quite happy, and he's comfortable with this situation. He did the crime, the major crime, the heinous crimes, but is still being rewarded by the very people who are standing behind the Rome Statute. Thank you very much.
Walter Veining.
I'm Walter Veining with the Institute for Environmental Security here in The Hague. I will share my minutes with my colleague Shirley Shin, sitting here. One of the major questions for the future is how to render justice in a world which is getting hotter and hotter. In Iran, cities are experiencing 54 degrees centigrade, 129 degrees Fahrenheit. Your skin is burning. It's getting drier. Next month, April, Cape Town will run without water. There are also places which are getting wetter, like Houston, where the alligators are swimming in the gardens. It's getting more polluted. There is more plastic in the sea than fish, people estimate. It's getting more crowded. We are heading towards 9 billion people, and we are losing species that are less than 4,000 tigers. We're talking about human rights, also talk, please, about tiger rights. How to create environmental justice in a world which is still fair and equitable, and not default to the custom of the sea. And one of these customs is the practice of shipwrecked survivors drawing lots to see who's to be killed and to be eaten the next day. We need drastic action, and amongst that drastic action, criminal justice action is more than needed. We should prosecute those who are willingly and knowingly, create the situation in which man and nature have rare chances to survive in a fair way, unless we take the right action. There has been a book, Unprecedented Crime, which just came out, and which advocates the use of criminal justice to those who deny climate change and those who perpetrate climate change actions. There's a recommendation by one of the people from the court, Reinhold Gallmetzer, who says, this is a very timely book. So this is our plea, and about the near future, my colleague Shirley Chin is going to see what we're going to do in the coming year up to the ASP at the end of this year.
Thanks, Wouter. In furtherance of what Wouter just said, thank you, Bill, for giving both of us the floor. My name is Shirley Chin, Green Transparency. Now, some have said that we have entered a period called the Anthropocene. In light of the challenges that were addressed today by a lot of distinguished speakers, we should challenge the court to consider, 1, the mutation of grave crimes, 2, the unrelenting impunity of perpetrators in some parts of the world, and 3, the plurality of victims. Now, this way, the court may be able to consider, amongst others, a solution that entails the prioritization of ecological/climate crime that affects us all. We invite the support of the court, the coalition, and those interested once more this year to push for this agenda for reconsideration at the next side event at the AASP this year. Thanks.
Vladimir Rudnitsky.
Thank you very much. My name is Vladimir Rudnitsky, and I have just a couple of brief comments. Yesterday and today we've been discussing various substantive issues relating to the establishment of the International Criminal Court. But we should not underestimate the importance of the organizational framework. And yes, there was a preparatory process at the United Nations, but you cannot prepare yourself for everything, and we had to adjust our procedures, reassign staff in order to face some unprecedented challenges during the conference. Actually, I myself benefited from this flexibility. At first I was working in the Secretariat of the Drafting Committee of the conference and in the Secretariat of the Credentials Committee. That an increasing workload didn't allow me to continue like that. And luckily for me, my colleague and friend Mpazi Singela became the Secretary of the Credentials Committee, thus allowing me to concentrate on my work in the Drafting Committee together with my colleagues in the Codification Division team of the Office of Legal Affairs. But it's not, and there are other examples of flexibility and need to readjust procedures, format, and so on and so forth. But it's not only about the Secretariat. What I want to emphasize that we have to analyze this organizational framework in relation to the establishment of the ICC from the standpoint of the ever-increasing interaction between the United Nations and civil society. In my opinion, the ICC coalition's experience is extremely important in this respect. It's one of those examples of successful interaction. So I believe this experience has to be further analyzed, summarized, and utilized for the benefit not only of future conferences and some other activities, and not only in the context of ICC, where it is extremely important, but in the context of the establishment of what we are trying to achieve, the rule of law in international relations. So a practical suggestion may be, maybe ICC would agree to prepare such a study analyzing the possible and past and future probably organizational modalities for that kind of interaction, and suggest it to the international community. Maybe it could be prepared in cooperation with the delegations and secretariat, those who established and participated in the establishment of the ICC. So that would be my little practical suggestion, and thank you very much. Thank you.
Merci. Je parle en français. My country is Congo Kinshasa. My country is world. Yes? Lorsque la Cour pénale, ça a été fait, j'étais très contente. Parce que je me suis dit, enfin, il n'y aurait plus des gens qui vont tuer les autres sans être inquiétés ou sans être mis en prison. Mais ce que je vois dans mon pays, le Congo, Kinshasa, il y a des millions de morts et les criminels sont toujours en train même de rigoler et d'acheter le monde avec l'argent du sang du Congo. Nous sommes des êtres humains, nous ne sommes pas des animaux. Si nous sommes tous des êtres humains, nous devons prendre conscience que la primauté, c'est l'être humain. L'argent, ça passe, tout passe. C'est pourquoi je dis merci à cette coalition qui a été faite pour que la justice soit mise à la lumière. La justice doit être faite dans ce monde. Merci.
Jutta?
I believe it was Janet who said your first 20 years were easy. You have your worst 20 years to come. And you were referring in particular to cases, investigations in Afghanistan or Iraq and the crime of aggression. And I do not underestimate the opposition that will arise against the court due to these cases and due to this particular crime. But I've often wondered if it will not be the opposite. How would the last 20 years, the last 10 years have looked if we had the crime of aggression already on the books fully in Rome? Maybe we would have had a few wars less. Maybe we would have had fewer migration streams. Maybe our political atmosphere would be quite different than it is now. And my hope is, with this activation of this crime, that we will maybe prevent a World War III, and that our next 20 years will be so much better than otherwise.
Amnesty International?
Thank you very much, Bill. I've got a fairly personal intervention to make, so I'll say that I'm not doing it on behalf of Amnesty International, because if I did, I probably wouldn't be in a job tomorrow. But I hope it won't be too bad. I mean, the first thing I think we need to address is a bit more honesty, which is, of course, the next 20 years are going to be very, very difficult, I think. We talked about challenges. Now, of course, some challenges are good. As Richard quite rightly said, when you go after the most reprehensible people in the most powerful countries, the challenges you're going to face are going to be enormous, and we have to face those challenges. But what we are struggling with, I think, somewhat, is the lack of a safe space to also discuss some legitimate criticisms. And frankly, I think to an extent, we can't go on for the next 20 years if we don't address some of the elephants in the room that exist in international justice. We can't go on for the next 20 years if we keep putting a Band-Aid over this and doing it another year and put another Band-Aid over something and do another year. It's not possible. We won't be here in 20 years if we don't get to some of the real structural difficulties facing international justice and the ICC at the moment. That's, institutionally, that's saying, does the ICC have the solid procedural, strategic policy foundations for the next 20 years? Does it? For states parties, are they really committed to the ICC? International justice is a very good idea unless it starts affecting you or your nationals or your state. And we need to accept that reality and see what we can do on that. And that brings me to a fairly obvious point when we talk about the next 20 years. And I mean no disrespect, but I think one of the elephants in the room is that most people here, I hope you will be here in 20 years' time, but perhaps not in the same capacity. But that's a very real issue. Mariana talked earlier today about a black hole between the folks who are in Rome and those of us now. And it's a real thing. And we really need to start thinking about the future. Where are the people coming from southern states? We need gender representation. All these things are vitally important. And I really hope we can talk about that for the next 20 years as well. Another elephant in the room is the bubble. I talk about the Hague bubble. International justice is a great success for us here, and we all agree it's really important. Unfortunately, we aren't the people we need to convince, and the people over the next 20 years probably won't agree with us. So we need to, the only way to get out of a bubble is to realize you're in the bubble. And that's within the ICC, within the states parties, within the NGOs. We've got to get out there. We've got to make international justice relevant. Because I'll be brutally honest with you, in a number of situation countries and with my colleagues who are being threatened in some really nasty places in the world, it's not. And those are the kind of people we need to be thinking about going forward. Within the ICC, the states parties and the NGOs, I think, again, we need to reassess perhaps what that relationship has been. It's been hugely beneficial, I think, to all parties. But with 20 years of working in our bubble, perhaps hasn't always had the outcomes we want. I think to some extent, and I say this personally, some NGOs can be too close to those making independent decisions and right at the top of these bodies. I think too often some NGOs are keen to be diplomatic. We have to play the game, but at the same time, we're not diplomats. And if we really believe in international justice, we should be willing to stand up for that. I think states parties, in their role, well, again, do states parties, all states parties, really want to see an effective ICC? They need to take a hard look at themselves for the next 20 years. One of the major issues that I can see is that everything has become a diplomatic negotiation at the court. Cooperation is moving towards being a diplomatic negotiation, not an obligation. Budget is a haggle between the states every year on a diplomatic negotiation. Legal aid provides rights for victims and defendants. A purely technical policy to make that sure that happens is now a diplomatic negotiation. We have to have a fair, frank discussion about what that's all about. Talking about leadership, and again, who will stand up for the court in the next 20 years' time? I think within the NGOs there are a number of young, deeply committed people who are working on international justice. I think particularly in the NGOs because, well, frankly, we work for Magic Beans and we're really committed. But we need to make sure that that's across the board. Within the states parties, within the young diplomats, we keep talking about young diplomats. I'm not a diplomat, I think that's quite obvious. But where are the young diplomats getting their messaging from? Are they being told we need to nip this thing in the bud? We want a nice court here, but frankly keep it in its box? Or are they really being allowed to stand up to the UN Security Council? Are they really being allowed to have that energy that you talked about in Rome? And also within the ICC, the leadership. Again, vitally important. We've got 3 new leaders coming in, which is a massive moment for the court. Within the prosecutor, we've had 2 very good prosecutors, but we need a new prosecutor who's going to go into the most difficult situations against the most powerful states, major realpolitik battles, and be fiercely independent and say, this is the budget I need, this is what I need to do my job, and this is what you've got to do. We can't have a prosecutor who won't do that. And this is why it's hugely important for states who elect that to, those states who believe in that kind of prosecutor need to start working on that now. within the presidency. We're going to have a new president of the court soon. We need, again, a president who is going to make sure that the plenary doesn't have 18 opinions on every single thing that comes out of the court. A president who will stand up for the court for the next 20 years openly and frankly, and who will say, we don't want judges within the ICC who are actively undermining the budget negotiations. We don't have any time within the plenary for judges to send emails around that actively undermine other principles of the court. That's something we absolutely desperately need, and we need to have this frank discussion. I think in terms of future leadership, I think it's vitally important for all the senior people in the NGOs, in the states, in the court to be aware of the need to promote young, motivated people to the top. As I said, we need young diplomats moving forward who are committed. We need young NGO activists who are brought on and able to lead those organizations. And again, at the ICC, we need a proper system where young, motivated people who will stay can move up through the system and use their experience. We can't have a system necessarily where people stay in the role for 10, 15, 20 years, and there's really no social mobility there. And when I say we talked about international justice as a career, and I think that's probably true, but then we need to think about that. What does that mean? Well, the first thing we need to address is internships, I think. That's a major issue that's vital for us. The nature of internships means that only those who can afford it or come to The Hague can be interns. So when we talk about international justice careers, again, we'll probably just keep it in this bubble. And that, I don't think, is good for the future of the ICC. And international justice is a career. And what does that mean? Well, I think it also means people need to be able to be frank and not worried about how it will affect their career. Young NGO activists need to not be afraid that if they speak out, they'll never get a job in institutions, which I hear fairly regularly. And that goes across the board. I think we mustn't be afraid of new ideas. We mustn't be afraid to hear what we don't want to hear. We must accept the criticisms, even if we think they're not valid. Because people on the ground are saying that the ICC is selective. People on the ground are saying that the ICC will never go after powerful states. And we need to address that openly and frankly. And the last thing is, I guess, a bit of a pledge for us just to say there are young, committed people. We need the people in Rome to teach and pass down their knowledge and expertise. But at some point, and I hope in the next 20 years, we won't hear so much about Rome because it will be irrelevant in 40 years' time. But I hope the court isn't. So thank you.
So now, if I can ask the presenters on the panel if you have any last comments you want to make from the questions or references, please do so.
Lots of contributions, lots of different views, some critical, some sympathetic. Not a single voice has uttered that the ICC or the Rome Statute would be obsolete, and that gives hope. As I said earlier today, the statute is in the world and nothing will take it away. Even if 100 out of 123 states would withdraw from it, it would still exist. It would still be there. It's codified that nothing can take that away. It will never be diminished. It will never be disappearing. The question is to what extent we are able to implement it. The question is to what extent we want to implement it. And if states now are afraid about what they have done in Rome, suddenly we are actually targeting sitting heads of states. Wow, I think this is a deterrent effect that many, many other criminal justice systems dream of. The deterrent effect of criminal justice is a dream of every prosecutor, of every judge. And I haven't seen a single country in the world, east, west, north, south, doesn't matter, where it works. But if here states start panicking, we need to change the statute, otherwise it's going to hurt us sometimes, wow, that's a deterrent effect. And I think those who have created the statute and those who implement it today, you should be proud of that. Thank you.
I'm going to be really, really short and just maybe ask everyone here, because we're the ones who are who've showed up to defend and protect something that we've built. Let's not forget why we've built it. Let's not focus so much on
the day-to-day detail. It's hard, I know, we have to do that part. But let's not, in doing so, let's not forget that what we're trying to do is instill in populations around the world, especially affected populations, that we are providing them an alternative to violence as solving problems, as solving past injustices. And if we can keep this in our minds as we do our work, I think it will focus us and it will let us go in the right direction. Thank you.
Two thoughts. One, the colleague who raised, as I understood it, the issue about crimes that were committed before the Rome Statute's entry into force, and I hope I'm getting that question correct. I think we have to press and do all that can be done with national courts, recognizing the difficulty where there is political opposition or a lack of political will to go forward on trials of those accused of serious crimes that occurred before the Rome Statute was enacted. I think we have to press for those trials, and then I think we have to look beyond the borders of those countries, and I know that it was recently that the Netherlands began a prosecution of a member of the Ethiopian Armed Forces who was implicated in killing 100 people back in 1975. And that gives me some encouragement that it's not only the territorial states who can conduct such trials, but there are other options as well in terms of national courts. Beyond that, I think the mechanisms of transitional justice, of memorializing, of documenting, of never forgetting what happened and honoring those victims, even if those who perpetrated crimes against them can not be brought to trial. I think that's something important to do. Final point on Matt's query. Are all the state parties committed to the ICC? I think the answer there is pretty clear. No, they are not. And what is the road forward then? It is rallying those who are to step forward and, in the face of difficult conditions, really make their support for an independent court known and as a dividing line in a way so as to push those more ambivalent states parties, or even those who intend to keep the ICC limited in a box, have a much harder time doing so. Concluding, I'd say I think this anniversary year is really one of the best opportunities we will have to take that particular effort forward. Let's make the most of it.
Thanks. I'll just address two of the speakers. The speaker about Darfur, it was mentioned this morning that, yeah, the ICC doesn't have exactly the opportunity ICDY had in terms of conditionality. And we saw that the former Yugoslav. Okay. So commenting on the lack of arrests for the situation regarding Darfur, And it was observed that the ICC doesn't have the exact situation similar to ICDY, where the EU was able to impose conditionality, and before that, the US conditioned financial assistance to countries in the region. So we can't use exactly that model, but what we can see is that countries don't do surrenders until it really costs them not to do so. So we have to make non-cooperation cost much, much more than it currently is. So slaps on the wrist aren't working. So we have to go to, I think, a completely different level if states are serious about achieving this. And there's just the first comment on crime of aggression. This will be a real challenge to the court. Well, first I have to say I don't anticipate immediate cases because actually the threshold for this crime is quite high. It's a manifest charter violation by its character, gravity, and scale. There's also limitations on jurisdiction. So these cases may not come along, which is good because the court needs to develop the expertise. This is jus ad bellum law. This is not the law on genocide, war crimes, crimes against humanity. It's a different body of the law. And they need to elect some judges who know this law. But actually, ultimately, we don't want cases. That's the point. We don't want cases. We want to deter aggressive use of force, and having this out there as a threat to try to do so. Thank you.
Thank you very much. And if you'll join me in expressing our deep appreciation to today's presenters. And then as we have this last 15 minutes, first I would like to ask you to join me in thanking very much the staff and the volunteers and the interns of the Coalition for the International Criminal Court who organized this under tremendous stress and pressure. So if you could stand up, please. Well, no, I meant the staff. I think it's been actually quite a successful 2 days of launching a commemoration and stock-taking process on the 20th anniversary of the Rome Statute. I think we've learned a lot about the different political, legal environment that we had on June 17, 1998, and February of 2018, and the challenges that that changing environment presents to us. I am also share with Darrell Robinson, Professor Robinson, this real sadness that the academic community, which was so fair and constructive, even though they would be critical, but they were fair and constructive, has become much more superficial in their understanding and analysis. And as each legal advisor usually rotates every 3 or 4 years, ambassadors rotate every 3 or 4 years, this is a constant educational challenge of what is the Rome Statute, what's the Rome Statute system, what's at stake here. And we do have to find out about, or find ways to address this. I agree with Amnesty about the bubble. I think it can look at 2 ways. I was trying to figure out at the Nuremberg Academy in one of my last interventions there about the size of the bubble, and it has to be somewhere less than in the tens of thousands, and maybe it's even in less than 10,000 or something, globally. And yet it has, all these years, put together an extraordinary new system of international criminal justice and built a court and is in 20 different situations and examinations at this point. And that few people can have that big of an impact is also a significant thing, even though that fact that it's a bubble and so isolated presents enormous challenges that we have to address. And I think it will be this younger generation now and the new tools of communication, which are actually having themselves extremely mixed impacts on, well, I don't need to talk about the fake news of reality of media, even in the largest democracies at this point. But almost all of our staff are young, and 70–80% are women, and I think you are going to see a sea change in this bubble in this next decade, and it's going to be a change that's going to be for the better in terms of diversity and gender and expertise. And I think we are seeing it. Now, whether we can find the ways to make the bubble break out communication-wise around the world is another challenge, and I don't think we're the experts that will be able to solve that. I think we have to find those other bubbles that will be able to serve this goal. We also talked about the performance indicators that the court's doing, and to try and apply those performance indicators perhaps to the Assembly of State Parties, because this is the organ that I think we have to rely on the most in terms of the gaps that we're seeing and the dangers that we're going to be confronting. I think Klaus is correct. The institution is up, it's codified, it's there. It is now, how do we make certain that the political oversight remains? And on this, I think the key issue is that this 123 governments is mostly the small and middle power democracies, emerging democracies. It's probably at the limit of those types of governments, and so the next 10 or 20 are going to be much more difficult to bring in. But we do have a number, I think, over this year and next year we ought to really reach out to and try and work with the Assembly and the court and regional organizations and others, and really identify what are 10 or 15, especially smaller countries that haven't said yes, that we need to bring into the system. And succeed with that type of a goal. The reality of the donor world is, whether it's government or institutions, foundations, has, I think, really gone backwards in the last 20 years, unfortunately. The indicators and the deliverables and the quantification of everything, how do you quantify if you've prevented a mass atrocity crime? How do you prove that negative? And so much of what we need to be doing, as a number have said, is to maximize the deterrent impact of the Rome Statute System, maximize the complementarity capacities of the Rome Statute System, and the success of all of that will be negatives you can't prove. So it is a huge challenge, again, a big failure of academia, I think, and the people who have taken over in terms of the grants and the assessments. But I do believe, as others have said in these 2 days, that this is one of the great multilateral institutions that has been created, and that it has almost a existential role to play in whether we're going to exit this century, how the human race is going to exit the century, and whether the environmental ecocide groups, dreadful views are correct, or the World War III prevention concerns are correct. This is an institution. And if you look at the 123 countries, there's no US, no Russia, no China, no India, none of the major religious or the authoritarian governments, the dictatorships, the divisions within the UN system of the EU and non-aligned, etc. That isn't involved in the Assembly of State Parties. This is a group of countries, a multilateral group of countries that ought to be able to rise above all of these challenges and at an, as Richard Dicker was saying, at an enormously inexpensive cost. The 160 million euro or so that this system costs at this point is a fraction of what governments are spending every single day, whether it's on their refugee issues, terrorist protection issues, peacekeeping issues, etc. And somehow we've got to reach the ministers, finance ministers, the prime ministers, the parliamentarians with this reality. We don't have time today, unfortunately, or didn't have time today for some of the videos that we wanted to show, and I especially am sorry for Gustavo Colon from Colombia, Jose Guevara from Mexico, and Harry Verwey, who is the Dutch ambassador to Burundi, who sent us a very nice video. We will, the coalition, put this online, and it'll be with all of the other videos and much of, I hope, of the 2 days of these events, this commemoration, will be available for you and for our 2,000 other NGOs out there, and hopefully for governments to take advantage of. We really want this to be the beginning of a cascading of events over this year. We've written and are writing to every single justice minister and foreign minister in the world. We hope people will go back and ask them, when are you going to do your event on the Rome Statute this year? How are you going to do it? How can we help? Can we be included? Etc. Ben Ferencz, I thought, and again in his inimitable way, that this is not mission impossible. What is mission impossible is if humanity doesn't take the dramatic turn from the politics of the last century and the devastation of the wars and now the new mechanisms of wars and terrorism and move towards the rule of law, justice, and human rights as the governing principles of human society. I promised that as we would finish today, that we would stand for a minute in silence for the victims, especially the victims that the court and the Rome Statute System have not been able to save in this last 18 years, but also for those wonderful leaders that we've mentioned in the last 2 days who gave so much to this project of international justice and peace. So if you would stand and join me in a minute of silence. Again, thanks everyone very much for these 2 days. We very much appreciate this, and we hope to see you again over the years. And you should, I hope, be very proud of this historic achievement and the Rome Statute, the court that we've created. But we have unbelievable challenges that we need to overcome. So thank you again very, very much.